a few minutes before noon. My name is Cynthia Smith. I am the Chief Legal Counsel at the Public Service Commission, and I'm here to give you, in the time we have, the PSC 101. Just by way of background, I've been the Chief Legal Counsel at the PSC for over the last 10 years, and prior to that, I was an attorney, a partner at Michael Best in Friedrich, doing environmental law, environmental litigation, and in particular, environmental litigation for public utilities. I hope you can see me and see my presentation. Unfortunately, I can't see all of you, and I can't see the chat, but I do encourage you as I go forward. Lauren is here, is online with me, and she is keeping an eye out for any questions. So I invite you to, in the middle of the presentation, or I'll allow some time at the end to use the chat feature and ask any questions, and Lauren will let me know and stop me so that I can answer your questions. So with that, we'll get started. So I'm going to cover kind of the basics, as I said. We're going to start with who the PSC is, kind of what our organizational structure is generally, what we do, our authority and jurisdiction. And I'm going to try to highlight, given the nature of this seminar, highlight what we do specifically relating to renewable energy. And in this regard, I could spend an entire 45 minutes talking about one particular project or one particular aspect of our regulation in this area, but I really just am trying to provide you with an overview. And I'll end with sort of what I think is important of a procedural overview, so that you know how the commission works, how we make our decisions, what are the processes and procedures. And I'll try to touch on, again, I don't have the time to get into the details of all of our decision making and the rules that apply, but give you a sense of some of the considerations the commission does follow when it is making its decisions. And most importantly, I'll show you how to get information from the commission and how you can participate, especially in matters relating to renewable energy. So who we are an independent state agency. We oversee more than 1,000 Wisconsin public utilities that provide electricity, heat, water, and we have limited telecommunications regulation. So the first thing that is the primary jurisdiction of the commission really turns on this who is a public utility. And I'll get to that in a minute, but let me give you the overview of who we are. The commission, as the independent state agency, the governor appoints 3 commissioners to serve staggered 6-year terms. Commissions in other states, some have more commissioners. Some have commissioners who are elected as opposed to appointed. But here in Wisconsin, our governor appoints the commissioners for these 6-year terms. The PSC's history dates back well into the 1800s, when it was first created by law in Wisconsin Statute 1579. From an administrative perspective, the day-to-day activities of this are vested in the chairperson, and the governor has, in addition to the authority to appoint the 3 commissioners for 6-year terms, has the additional authority to pick one of the 3 commissioners to serve a 2-year term, and they can serve more than 1 2-year term as the chairperson. So our commission is currently constituted, consists of our chairperson, Rebecca Bach, Commissioner Nowak, and Commissioner Hebner. The PSC's mission is to ensure safe, reliable, affordable, and environmentally responsible utility services and equitable access to telecommunications and broadband services. Our regulation, as an independent state agency, we only have those powers that the legislature gives to the agency. And our powers can generally be found in Chapter 196 of the Wisconsin statutes. As I mentioned, our bread and butter is the regulation of public utilities. In Wisconsin, Chapter 196 gives the commissions pretty broad authority to supervise and regulate every public utility in this state and to do all things necessary and convenient to its jurisdiction. So as I mentioned, who is a public utility? And that is defined by state statutes. And I'll just read part of it to you here. As any corporation, company, an individual, association that controls, operates, or constructs any plant or equipment within the state. And here are the key terms: for the production, transmission, delivery, of furnishing of heat, light, water, or power, directly or indirectly, for or to the public. So as you can see, the statute is rather broad in the definition of public utility. It does have some specifically set forth exemptions of types of entities that are not public utilities, but by and large, the public utilities that most often come within the Commission's regulation, and what I think most folks would appreciate are the public utilities, are first, the investor-owned electric utilities. Here in Madison, you have Madison Gas and Electric Company and Wisconsin Power and Light. In the rest of the state, there are the Northern States Power Company in the northern part of the state, and you have Wisconsin Electric Power in the Milwaukee and southern part of the state. Another public utility that is regulated by the Commission, those investor-owned electric utilities, they're primarily tasked with the generation of and distribution of the energy. What in 2000 era, the state determined that we were going to just have one entity take care of the actual transmission of energy within and outside the state. And that entity for Wisconsin is the American Transmission Company is one. And there is also ITC Midwest is another. The Commission also regulates municipal electric utilities. Again, using kind of the Wisconsin, and I'm on the west side of Wisconsin as an example. Sun Prairie, for example, has a municipal electric utility. We regulate the natural gas utilities. So your gas distribution from Madison Gas and Electric or Wisconsin Gas in the southern part of the state are examples. Wisconsin's, again, a little unique in that we also regulate the water utilities. And as I mentioned, there's 5 investor-owned utilities, about 70 to 80 municipal electric utilities, a handful of gas utilities, and the largest group of public utilities that we regulate, unlike many states, are water utilities. And here in Wisconsin, there are over 570 water utilities that the Commission regulates. The Commission used to have more authority over telecommunications, but now with deregulation of that industry, the Commission's regulation of telecommunication is pretty limited. In addition to those that we regulate that fall within the definition of public utility in the statute, there are those who may engage in certain activities, which then also result in the Commission having jurisdiction over them, even though they don't meet that statutory definition of public utilities. And one, maybe that's a plumber or some other type of, maybe a landscape company, etc. If they go and they excavate for a homeowner and they fail to call Digger's hotline, if a complaint is brought and certain statutory prerequisites are met, the Commission actually now has jurisdiction to enforce that violation. Because again, part of the Commission's job in its regulation of the natural gas utilities is maintaining that we have safe structures and safe practices surrounding those structures.
Hey, Cynthia,
Yes.
I just wanted to let you know, we've lost your slides. Could you try sharing them again?
Sure.
Thank you.
All right. Is the view okay, or do I need to change the display setting? How's that?
It looks great now. Thank you.
Okay. So sorry about that. Not sure where we cut off. And Renew, they'll have a copy of these slides. And I certainly, if you would like the actual hard copy, those certainly can be emailed or otherwise distributed to the registrants. So as I was indicating, to fall within the commission's jurisdiction, you don't necessarily have to be and fall within that bucket of a public utility, but you might have to engage in certain conduct. For example, electric cooperatives or independent power producers. I believe Invenergy might have been the sponsor of the speaker just before me. They're an example of an independent power producer. And here, the commission's jurisdiction is limited to only those circumstances when that particular entity wants to construct a large energy infrastructure, such as a power plant or a high voltage transmission line. Similarly, while we regulate water utilities, we do not have primary jurisdiction over wastewater or stormwater or sewage districts. However, if the law provides that if someone believes that the rates, rules, or practices of the municipality in those areas are unjust or unreasonable, they have the right to file a complaint with the commission. We also don't regulate cable TV or the intrastate gas pipelines, the Northern Natural and some of those that transmit the gas resources across multiple state lines. Okay. So keeping in mind who we regulate, what it is that we regulate. And again, Chapter 194 it contains a lot of provisions, but in summary, what the commission does are these areas. We've just come through this, what we call rate cases, where the commission will set the retail rates for public utilities. The commission also authorizes the construction of various utility infrastructure. And we also monitor the financing and other accounting related matters for utilities, mergers and acquisitions or sales, and various holding company issues. The commission also is a voice for folks to come to if customers have complaints about services they're getting or ability to pay or what have you. They can contact our Bureau of Consumer Affairs, and we try to work with the utility and the customers to resolve those questions relating to services. In addition to the regulatory work that we do, the Public Service Commission administers several state and federal grant programs, which I've listed below. And I will highlight the Energy Innovation Grant Program in a little bit. So how does that apply in the renewable realm? Keeping in mind those sort of broad provisions. In the renewable area, the commission authorizes the construction of renewable energy resources, whether that be wind or most recently what we've seen is a lot of construction of solar electric generation facilities. And I've listed some of the kinds of cases, and those numbers and some other things will make more sense as I get a little further in this. But in those cases, the commission, in looking at the applicable state law, had to determine whether or not it was in the public interest for the particular facility to be constructed. If it's constructed by a public utility, the commission also has to consider, does it really need that extra generation resources? What are the impacts of the costs of authorizing the construction of that? So when the commission is making these determinations, it's really looking at the statutes and the specific statutory criteria, which in addition to making this broad public interest determination, we have to make sure, will it have an unreasonable impact or undue burden on local land use? Have brownfields resources been used to the extent practicable? And other specific statutory criteria. But I think commissioners will tell you that construction cases are, and in particular transmission cases, are challenging because I'm sure you've all heard the NIMBY reference, not in my backyard. While many people may want renewable resources, not everybody wants a solar facility in their backyard or transmission facilities that are needed to transmit the generation from that facility. So the commission really has to look and kind of balance. A lot of what they do is balancing and weighing the public interest, the benefits, the costs, and coming to a decision for a reasonable basis for its decision. Another major component of what the commission does in the renewable area is authorize certain renewable energy related customer services and programs. And here again, I list some types of programs. And as you can see, if a utility wants to offer an electric vehicle program, it needs to come to the commission and ask that it be given authority to offer that service. Similarly, if there are other renewable programs or services like solar or community solar or other related customer hosted programs that interact with the utility, those are all things that the commission must give the utilities the authority to do. Oops, sorry. And as I mentioned, we also administer renewable programs outside of just the utility specific programs. In particular, the commission has a statewide renewable resource and energy efficiency program known as the Focus on Energy program. Here, the public utilities are by statute required to fund this program, and the commission oversees that program. The utilities hire a program administrator that the commission oversees. The commission makes decision as to what does that programmatic offerings for Focus look at, and sets the budget for those programs. Looks like we have 2 chats. Are those old, Lauren? I just saw a pop up with the
Yep,
2 chats.
I've got one that's coming through right now for you.
Okay.
What statutes are needed in Wisconsin so that the commission could really take into consideration the full cost of carbon and climate change? Or are there existing statutes that address carbon and climate change?
That's an excellent question. We have existing statutes that the commission looks at when, as I indicated, it determines whether or not the construction is in the public interest, whether the costs or benefits are taken into consideration in setting the Focus on Energy program. For example, the commission looks at the as to determine whether that's a cost-effective program, will establish a cost of carbon. So that is certainly among the falling within the broad requirements that the commission's decision establish just and reasonable rates or authorize construction that is in the public interest. Those are certainly some of the things that the commission considers in making those decisions. Okay. In addition to the Focus on Energy program, the commission has a specific, now it's a grant program. It originally was a loan program, but the commission has converted that to a grant program and sort of rebranded it. And it's called the Energy Innovation Grant Program. And I'll put in a little plug for that. We currently have an open grant round pending, and I'll walk through kind of how the commission comes to decide what is included, what kinds of projects are eligible, etc. In addition to those items, the commission also establishes the rules. So we have Wisconsin Statute Chapter 1 96 that provides the statutes. Many of those statutes then specifically provide or direct the commission to establish rules that provides more of the granular nitty-gritty of the regulations. And one such area that I'll just highlight, because the commission just opened it up, is, and I think I have a typo there, I'm sorry, it's chapter 119, the rules for interconnecting distributed generation facilities. The commission also, in addition to dealing with specific programs or specific cases, the commission can, on its own initiative, especially where it wants to take a broader policy look at something, open generic dockets. And the commission has currently 2 generic investigations in this area, the electric vehicle policy and regulation generic, as well as the parallel generation purchase rates. And that docket is looking at what are the appropriate rates that should be charged and avoided cost and things like that when you have distributed energy resources that are interconnected with the grid. Just returning quickly to the organizational structure, as I indicated, the decisions are made by the 3 commissioners. And because there are only 3 commissioners, one interesting component of the commission's decision-making is that the commission needs to make all of its decisions in an open meeting. And because there are only 3 commissioners, the commissioners can't talk to each other about the substance of their meetings because that could be considered a walking quorum in violation of the open meeting. So the commissioners have to hear for the first time what their colleagues are thinking about a particular matter at the open meeting. So the commission has their own independent staff, in addition to access to the 150 or so commission staff. They have their own personal, they're called executive assistants, but they're really more of sort of a specific policy advisor to the commission that works with their individual commissioner in helping them think through the various matters that come before them and require a decision. In addition to those duties, the EA to the chair is really helps the chair with the day-to-day operations of the commission and really acts more as a chief of staff in those duties. In the commissioner's office, that's where I'm housed. And the commission, when it acts as a body, and the commission secretary is the one who's authorized to then affix her name on behalf of all the commissioners in establishing a commission order. We also, you'll hear when we talk a little bit more about the mechanics of how we make a decision, we have an administrative law judge on staff who presides over our contested cases and helps get the matters set for adjudication for the commission. See some more questions come in?
Yes. One question is going back to the open docket on parallel generation and how right now in specifically in the We Energy service territory, in summer months when you overproduce, you can get paid less than the amount you're paying in winter months. And is that part of the docket that they're looking at? And is that part of the consideration in this docket? Is that something that's possible to change under this docket?
Right now, the commission is sort of at the beginning stages of that investigation, and we have commission staff have prepared several pieces to the commission, kind of seeking their guidance. And in fact, we are soliciting input from those that the commission, stakeholders before the commission, to help us frame exactly what the issues for consideration are or should be. And this is intended, this particular docket is looking at it broadly across not just We Energies, but all public utilities in the state.
Awesome, thank you for that. And a couple more questions we can put in right now.
Sure.
The next one is, It seems that the Renewable Energy Rider and similar programs position solar as an extra cost or a luxury rather than maybe a new normal or for universal clean energy. And is there a way, in your opinion, that we can make sure that the state and the PSC makes this shift to seeing renewable energy as more of a new normal than a luxury? And how can a cost and benefit analysis of utility factors and externalities of not just climate impacts, but health impacts as well? So how can we include health impacts in this benefit analysis when the PSC is looking at it?
Yeah, and again, obviously there's folks who want to talk about specific projects and specific matters. And that's really, as I said, I could talk, an entire 45 minutes just on that. But so I think what's important, instead of saying substantively what you can or can't do, I think it's important to understand how you can get those views before the commission. And that's what I'm getting to in this presentation. The commission's has numerous ways in which we solicit and accept evidence on those variety of matters. And so I can get to that going forward. But I don't know that this is the best. This is intended to be a 101 as opposed to a real deep dive on any specific projects. So I'm going to try to keep it at that high level so we can get through, especially for those that are just don't even know some of those real nitty gritty that some of you do really get the 101 that this is intended to provide.
Awesome, thank you. And we have one more question I'd like to throw back at you before we carry on. So are the utilities and or MISO considered a regulated monopoly for the power plants and power generation sources as well? Is this something that's up for debate?
Sorry, could you repeat that? The commission doesn't regulate MISO. MISO is the regional transmission operator and provides sort of the overall regional traffic cop, so to speak. So the commission doesn't regulate MISO.
So I think maybe a more clear question then is, are utilities considered regulated monopolies, and is MISO the one that is doing that regulation?
So yes, public utilities are considered monopolies, meaning that where you live is going to dictate who provides that service for you. I live here in Madison. In the part of Madison that I live in, Madison Gas and Electric is my provider. MISO really doesn't have anything to do with the rates directly that Madison Gas and Electric charges. The commission, it's our job to step in, and in light that it's a regulated monopoly, to look at and balance and make sure that the rates that they are charging are just and reasonable.
Thank you for that explanation. We're done with questions for now, so please,
okay.
Please continue.
Just briefly to finish up on the organizational structure, as I said, the commission has about 150 staff, and we're divided up into 4 primary divisions. The energy division, which covers, for this purposes, for the renewable, covers a good chunk of that, from reviewing the economics as well as the finances of various utilities and programs. We have the engineering is also in safety is in that division. The water division, the programmatic areas, which I've touched on, the focus on energy and EIGP grant program, those are housed in our DACIA, our Division of Digital Access and Consumer Affairs. And also Consumer Affairs plays a part in reviewing renewable programs or tariffs from the customer's perspective and making sure that those programs comply with various rules of service that are set forth in the administrative code. Our Division of Business and Operation Management is really internal focused and help provide the business services, IT, records management, etc. And then the Office of General Counsel, of which I supervise, we provide the legal support that relate to all of the work the commission does in all of those various divisions. So how the commission actually works really depends upon the nature and the type of case that is before the commission. They can range from very informal staff investigations. For example, if a customer has a question about a particular service or has a complaint about a particular service, they can file a complaint with our consumer affairs, and that is informally dealt with. And if the customers or utility are both satisfied, that's the end of that inquiry. It can also go all the way through the more trial-like cases, which we call contested cases. And those would be examples of some of the larger generation projects or rate cases that require a hearing. So the commission tends to divide things into two buckets, investigations and proceedings, and those are defined. PSC 2 sets forth the administrative rules that govern our day-to-day operations. As an administrative state agency, our processes and procedures also are governed by the Wisconsin Administrative Procedures Act in Wisconsin Chapter 227. Generally, how the commission works is that some action is either initiated at the request of the party or on the commission's own motion. So for example, if Invenergy as an independent merchant wants to build a solar generating facility of 100 megawatts or more, they're going to file an application with the commission and seek the commission's authorization to construct it. If there is a complaint about a specific customer complaint, for example, or that the rates are unjust and unreasonable, those are things that can be initiated. Or some other type of petition, whether that be a petition for the commission to engage in rulemaking or what have you. Common renewable resources, again, I covered some of those earlier in the what we do slide, but we also look, and what we're seeing a lot of, and we have a pending application that perhaps some of you have heard of, is when a utility wants to acquire renewable generation resources. Wisconsin Power and Light, for example, has a pending application seeking to acquire 6 solar generating facilities. Other type of investigations, again, some of the tariff changes or program changes that do not require a hearing. And those kind of programs that do require a hearing are if there's going to be a rate increase or there is going to be some diminishment in the service offering of a mandatory service, then the hearing would be required, and that would be what fall within the commission proceedings bucket. So our proceedings, the easiest way to tell the difference is a proceeding is something that is going to require a hearing by law. To help you understand and find information, because I really think it is a lot of the things that the commission does, you really need to see in action. And we are very fortunate in that we have an electronic records filing system that makes all the information readily accessible to the public. But in order to have that kind of secret decoder ring and know how to follow and track cases, you have to understand kind of what makes up a docket. And you saw in the earlier slides that would have some numbers and letters associated with it. Those are what we call docket numbers. And it has 3 parts. The first, every utility in this state and independent merchants that come before us get assigned a specific number. And that is a 4-digit number that applies in the first part of the docket number. The second number, or the second component, is a docket type. And here again, we try to give some heads up as to what type of case is it? Common types of docket types for the renewable energy would be FE, that's our focus on energy program. A TE, a tariff electric, which it would be any of the kind of renewable programs. or for the renewable construction, a CE. And the last part is either just a usual sequential designation of the utility and docket type, or it could be a docket type for the type of number that is the year, for example. So like for the EIGP grants, we're in the grant year for 2020. The electronic records filing system is a tremendous resource and is where you can find information. And it's also, as I'll talk about, how you can get information to the commission. You go to the commission's website and you'll see when you get to the website, you will see the e-services portal. And that is the gateway to provide you with access to a variety of records. If you have your magic decoder ring and you know the docket, the utility, the docket type, and the number, you can just punch it into these three boxes and you can either click here to get all the documents that have been filed, or if you really just want to know who's the staff that's involved in that particular docket, you can click there. If you don't know that information and you're really just looking to search, well, what has the commission done on shared solar, for example? You can click on the electronic records filing button here, and you will get to a more general screen where if you happen to be looking for a specific document, all documents on earth get assigned a number that you could type in there, or you can click here and that'll take you to basically a search page where you can, if you are looking for tariffs in the renewable area, you can put in TE, and then you can put in search terms where indicated. So it's a really great resource, and the first way to be effectively effectuate any type of change or policy development in the renewable areas is to know how to find information and to be able to track it. The next step is, well, how do you participate? Obviously there's several people who have things that they would like the commission to consider. So how you participate is really dictated by kind of the procedural bucket that it falls in, and what is the actual underlying request that the commission is reviewing. Is it an investigation or a proceeding? Regardless of what bucket it is, as I mentioned, the commission allows anybody to generally participate in those proceedings or the investigation. The level of that participation will depend upon, again, what bucket it's in, as well as what the nature of the underlying inquiry is. And I'm going to end by walking through some sample dockets so you can get a sense of what the different levels of participation look like. But in general, as the public, you can participate, but you can also, if you have want to be a party, and you can actively participate and seek discovery from the applicants, to offer more technical testimony, to be able to cross-examine witnesses. Those are the kinds of things that you would intervene and become a specific party. Also, by intervening and becoming a party in either a docket or an investigation or a proceeding, there are provisions which are beyond our scope today, but the commission does provide you can apply to see if the work you're going to do qualifies for intervener compensation, such that some of those expenses associated with that work are reimbursed or paid for by the commission. Commission staff, while it participates, our role is not that of an advocacy. And so we really rely upon other interest groups, whether they be renewable related nonprofits or interest groups, or a group like the Citizens Utility Board. We really, those are folks that come in and intervene and really advocate for their specific policy provisions. And there'll be competing policy provisions. And as I said, the commission weighs both of those. But from staff's perspective, Our objective is to make sure that we're asking the questions and getting as much of the information as we can in an objective manner so that the decision makers, who ultimately are the ones to make the decision, have the evidence that they need to do that. As I indicated, you need not to be a party to participate. We do offer opportunities, many opportunities for members of the public to provide comments. And again, our website is where you go. And at the bottom of the website, you will see an icon that says public participation. And you click on that button and it'll bring up all of the dockets that the commission currently has open for which it is seeking public comment. So how does this work? Let's take an example. And if you get a copy of this, these will be live links, but it gets a little wonky when I try to access live links during the presentation. So I just put those PSC reference numbers so that you can get a sense of what the documents actually look like. So here was a docket the commission considered where NSP was seeking to approve a specific renewable green tariff program. So it starts, as I said, by the utility first filing an application with the commission that describe what is this tariff, what are the benefits, what rules are implicated by this tariff, how will it comply with those rules, and why should the commission approve this program? The commission receives that information and commission staff begins its review, and the commission formally issues a notice of investigation that is released and indicates that the commission is considering this investigation. It identifies a brief summary of what it is and where folks can go to find information. Certain investigations have a statutory time period in which the commission has to act. For example, certain construction authorizations have to be acted on within a certain time period after issuance of the notice. Once the notice also says, hey, if you want to participate, here's how, and generally sets a time period in which you need to, what we call, intervene in that proceeding. There are specific commission rules relating to intervention, but as a general rule, those individuals or nonprofits or other public interest groups that have an interest generally are permitted to intervene and participate in the proceeding. Once we have the parties, or even if there are no parties, there are many dockets that the commission still investigates, even though we don't have other parties intervening. But this is where staff will do the fact finding and ask questions and submit data requests to the utility, trying to get more details in case, to fill out any gaps in the analysis, or if we think there are questions that the commission might have or want to address. This is where staff is gathering that information for the commission because it will base its decision on everything that is filed either in support or in opposition of a particular application. For your standard kind of investigation that doesn't require a hearing, commission staff generally summarizes the results of its investigation in a memorandum. And depending on the complexity, whether there are parties that intervene, that memorandum may then be submitted out for a public comment period. Once the comments are received, the commission then proceeds to reviewing the information and ultimately deliberating on that application at an open meeting. The commission has an open meeting generally almost every week, and typically those are on Thursdays. Under the open meetings law, the commission is required to publish notice at least 24 hours in advance of its open meeting and identify with a written agenda the matters that are to be covered.
Hey, Cynthia, we have a few questions while you're going through these
Sure.
procedurals. Our first question is, does the legislator get involved at all in these decisions?
Yes, they do. Obviously, they get involved in the discharge of their duties, whether that be by modifying or proposing specific legislation in this area. Because as I indicated, the commission's original authority is that which the legislature provides to it. In addition, say it's authority that the commission has. So maybe it's the construction of a particular renewable energy resource facility, and it's in that legislative district. That legislature may offer comments or testimony or submit other letters for the commission to consider as part of its deliberations.
Awesome, thank you. And then we have one more question before we wrap up here in a couple minutes, but you said earlier that the intervention deadline varies 14 days or shorter. Why is this?
Again, a lot of it will depend on the complexity or the scope of the application. And sometimes there are investigations that require very quick action in order to implement, or there is a need for the utility to get specific authority to do something. So in those circumstances, and again, they're not that common, but they do happen, the commission will shorten that intervention period. But it's important to note, even if a particular party may miss the intervention, there are provisions that allow for late intervention, as long as that intervener has explained why they failed to intervene, and they're sort of willing to take the case schedule and the issues as they find them, given their late participation.
Awesome. Thanks for all those thoughtful answers in your presentation. We have one more minute, Cynthia, so I'm going to leave it to you to give final remarks. Yeah. And then we hope to see everybody back in 15 minutes for our next sessions.
Yeah, I'll just quickly talk about there are more opportunities to participate in proceedings where there are hearings and there is an actual trial-like hearing and process. And again, the procedural overview of that can be found in there. The one thing I'll conclude on is the commission, there are rules in relating to what commissioners can and cannot talk about. And generally the commission speaks through its written orders, and it obtains information in which it bases its decision through the commission processes. There are prohibitions that preclude parties from talking to commissioners about the merits of pending contested cases. So again, in the limited time I have, that's an important consideration that folks should know about if they're looking to engage or reach out to the commission. And I'll just let folks, again, there's more slides about the process and a procedural overview about the grants. In particular, this EIGP grant that I mentioned is pending. Applications are due by January 21st. And so if you're interested in that, check out that docket and know that there is an upcoming deadline for that.
Awesome. Thank you everybody for coming to this talk, and thank you, Cynthia, so much for sharing with us. We'll leave you guys here and we'll see you hopefully in 15 minutes for our next round of sessions.
Thank you.
Bye, everybody.